APUS government students, here's a quick review to help you with your exams that you'll be taking here later this week. We're focused on civil liberties and civil rights. So we first looked at civil liberties. So make sure that you take a look at the First Amendment. Within that, we looked at a number of different cases. So just do a quick review of these cases. Within religion, look at Wisconsin versus Yoder and Engel versus Vitale. Engel versus Vitale focused on the idea of prayer in schools and how that's a no-no. Wisconsin versus Yoder focused in on the idea of homeschooling. So that was the Amish case. All right. The idea of freedom of the press, the New York Times versus the United States case, the preferred position doctrine. So the idea that there is a preferred position by the courts to publish anything from the press unless it is proven by the government that it could put our troops in danger. So that was the big issue within the New York Times versus the U.S. case. Then we spent a bunch of time looking at the freedom of speech, and we focused in on a couple of different places. So go back and take a look at the test. Remember that we first have to have state action, so we talked about that. So it has to be someone within the government that is saying that that speech cannot stand or they're being punished for that speech. We then classified the speech, and the two I want you to focus in on are school speech and political speech. We took a ton of time to focus in on school speech with the cases of Tinker and Morse. So make sure that you think back to our mock trial where we looked at issues of disruption, or we looked at issues of acts going against the school mission. Then I don't want you to forget about political speech because that's an important part of the First Amendment freedom of speech as well. So though we didn't talk about the Schenck case very much, it was in your reading. I want you to take a look at that as well because that's an important part of what the Supreme Court has said within the First Amendment, is that if we classify the speech as political speech, it's very difficult to stop. Schenck says there has to be a clear and present danger to that speech and allowing that speech in order to stop that political speech. So that's the important part of the Schenck case. So take a look at that quickly as well. The Second Amendment, we took a look at McDonald versus Chicago and gun rights. I think as well this was a good place for us to take a look at the issue of selective incorporation. So remember selective incorporation, utilizing the 14th Amendment case by case, right by right, and saying that not only does the federal government have to follow this decision, but the states and the local governments and the cities have to follow this decision as well. So case by case, liberty and right by right, incorporating to all governments that they have to follow these decisions. The Fourth Amendment, we looked at a number of different issues within that. Remember that all searches without a warrant are unreasonable, according to the Fourth Amendment, unless they match one of those exceptions. So take a look at those exceptions. High expectation of privacy in the home, not as high as an expectation of privacy with your vehicle. If, however, a search is deemed unreasonable, that evidence cannot come into court, and that's the idea of the exclusionary rule. Then we moved on to civil liberties. So here we're looking at ideas within the 5th, 6th, 8th Amendment, and then some various amendments. So these are additional civil liberties that we took a look at in the first part of this unit. So Miranda versus Arizona, right of silence, the 6th Amendment, Gideon versus Wainwright, the idea of the right to an attorney for felony cases. Then we took a look at capital punishment, that rule there. So make sure you review the things that we have there. And then we took a look at briefly the various amendments that create the right of privacy for abortion, Roe versus Wade, and the idea of the first trimester rights there that are present. Also take a quick look at the hurdles, so to speak, the undue burdens that we talked about there, where different states have tried to put in place different laws, different issues surrounding abortion. Some of those okay, some of those not okay. So take a look at those real quick. Just maybe a question or two on those. Then we transition to civil rights. So the big amendment within the civil rights is the 14th Amendment. So just do a quick review of equal protection laws. You don't have to spend a ton of time in terms of looking at those hurdles and memorizing where each of those fall into play and whatnot, but just get a big broad sense of the 14th Amendment, equal protection. So if the government is going to treat different groups differently, they have to have reasons to do so. When it comes to issues like race, they have to have a compelling reason. When it comes to issues like, taxing people different based upon their income, they just have to have a reasonable issue to be able to pass that equal protection 14th Amendment hurdle, so to speak. All right, so we took a look at some issues within Brown versus Board and school civil rights. So review Brown versus Board, which said separate is not equal. Then we took a look at a more recent case that deals with same-sex marriage, like Obergefell versus Hodges. Again, both of these cases using the 14th Amendment, calling for equal protection, and doing it in different issues in different ways. Then just a quick glance, just maybe a question about the federal laws that support these decisions. Civil Rights Act of 1964, certainly supports Brown versus Board and calls for desegregation. And the Voting Rights Act of 1965, which basically says you can't discriminate against people in terms of voting. Then we took a look at some gender issues. So take a look at the 19th Amendment, the Lilly Ledbetter law that was passed in 2009, which calls for the same payment for men and women in the same positions. And then we took a look at Title IX, a number of different issues there within Title IX, which calls for the equality of genders when it comes to education, when it comes to sports, equal opportunities, equal when we talk about scholarships, size of locker rooms, all those different sorts of things tie back to this federal law that was passed in the early parts of the 1970s. Then we took a look at a couple just real quick current issues. Affirmative action, kind of on the downhill slide today, was bigger in the 70s, 80s, and 90s. Did it promote racial assistance and what it was trying to do to provide opportunities for minorities? But you can also see it from the flip side in terms of, well, you're making decisions based upon race, so it looks like on its face reverse discrimination. So you've seen a number of different federal courts that have struck down affirmative actions attempts because of that high hurdle issue, no matter if it's trying to be a positive help for minorities. Then we took a look at voter identification and that idea of, does it help to root out fraud? So there's that argument on that side. But then we also took a look at the groups of people that don't have traditionally voter IDs tend to be those minorities and groups that have been discriminated within our country in terms of voting for long periods of time. So it's a really, really sticky situation within voter identification and those policies. Finally then, just the idea of what should I look for on the free response coming down with our groups. So you're going to see a free speech case in schools. So take a look at that First Amendment stuff. It's going to be at the Sixth Circuit. So you really want to focus in on, as you look there to the right, it's been at the Federal District Trial Court. It's now moved up to the Federal Circuit Court of Appeals for the Sixth Circuit. So we're going to tie together some things here from Exam 3, and we're going to tie together some stuff here from Exam 6. So, as your teacher, I love to tie in different things from different places and have you guys see where these things all kind of come together. So some ideas from exam 3. Well, how did it get to the federal courts? Talk to me about jurisdiction. How could it get from where it's at the Sixth Circuit to the U.S. Supreme Court? So maybe mentioning the rule of four, those sorts of things in order to grant that writ of certiorari that we talked about earlier on in the year. And then I want you to look at the issues within exam 6. So it's school speech, all right? You're going to see it classified as school speech. So then you're going to want to look at disruptions, school mission. I would look at Tinker versus Des Moines. That might be a precedent that you see in this question. And then the final question within this response is going to tie to, okay, it's at the Sixth Circuit. You're an attorney, let's say, for the student that has lost in this case. What can you do? Well, obviously, you can talk to me about appealing to the U.S. Supreme Court, getting that rule of four met, and writing a brief to have them hopefully support hearing that case. Or let's say you're the ACLU. What could you do? Well, certainly you could assist that attorney group in trying to get it to the U.S. Supreme Court with their brief. If it does get to the U.S. Supreme Court, you could talk about writing an amicus brief. So those are all the things I'm looking at for you to talk to me about with your free response. All right, email me with any questions that you have. Always here to help. I hope that few minutes helped to prepare you for your exam 6.